Welcome to the Law Offices of Chris M. Ingram's Immigration News Show. Today we ask, how does the recent federal ruling against USCIS's application freeze actually affect someone with a pending stuck case? Is this a permanent fix, or could the agency still block our progress? We would like to thank attorney Chris M. Ingram and staff at the Law Offices of Chris M. Ingram for their hard work in preparing the research for this show, which draws on a wide variety of news sources from both sides of the aisle, providing a balanced view. Attorney Ingram is also a vocal advocate for the rights and protection of immigration applicants, although our coverage is designed to be nonpartisan. Please don't forget to like, follow, and subscribe to our channel. We are also on Spotify, YouTube, LinkedIn, Facebook, X, Reddit, and Instagram, where we're growing rapidly thanks to our social media team. You can also visit our website on www.breakthroughusa.com. We'd love to see you there. Disclaimer. Please note that this presentation should not be intended as legal advice for your specific situation. If you, a friend, or family member would like a free consultation, you can visit our website at www.breakthroughusa.com and schedule an appointment. We'd love to hear from you and help you, if we can. We also like to point out that this presentation was created using AI hosts. Okay, let's dive in.
Thank you. I am really looking forward to unpacking this.
Yeah, so our mission for today's deep dive is to thoroughly unpack the legal research provided by attorney Chris Ingram. We're looking at a massive, breaking federal court decision from June 5th, 2026.
Right, the one that struck down a nationwide USCIS processing freeze. It's a monumental ruling.
It really is. But before we get into the heavy legal analysis, I want you, the listener, to really put yourself in this scenario. Imagine doing absolutely everything right.
Which is incredibly hard in this system.
Exactly. I mean, you navigate one of the most complex, unforgiving bureaucracies in the modern world. You fill out hundreds of pages of forms. You pay thousands of dollars in non-refundable fees. You attend the biometrics appointments. You sit through the rigorous interviews answering incredibly personal questions about your life.
You cross every single T and dot every I.
Right. And then, after doing all that perfectly, you face absolute unexplained silence. Nothing. Months turn into a year, maybe more.
And there are no updates on the online portal either.
None. There are no requests for more evidence in the mail. It is just a black hole.
Well, it is a unique kind of bureaucratic purgatory. And we see the psychological toll that kind of silence takes on people every day.
It must be devastating.
It is. Human beings are conditioned to believe that if they interact with a government agency in good faith, there will be some sort of procedural response.
Like a receipt or an approval.
Exactly, or even a denial. Because, a denial is a tangible decision. You can appeal it, you can read the reasoning, you can formulate a strategy.
Right, but silence.
Silence makes you feel like you are losing your mind. You start second-guessing everything. Did my nail get lost?
Did I accidentally check the wrong box on page 14?
Did my attorney make a mistake?
Yeah, you assume the flaw is with you.
Precisely. But what we are looking at today, based on the legal research provided by our team, reveals that the flaw wasn't with the applicants.
Wow.
This wasn't a standard run-of-the-mill administrative delay caused by a lost file or like an understaffed mailroom. This was a deliberate hidden policy.
A deliberate policy just to halt their cases.
Yes. The system had been quietly rewired behind the scenes to stop their progress entirely, and they were never notified.
That is just wild.
So for the thousands of people who experienced this, they need to know. They weren't crazy. There was an invisible wall placed directly in front of them.
Which brings us to the core of our discussion today. We are unpacking how a federal court finally pierced this veil of administrative silence.
It is a fascinating look at how the government operates behind closed doors.
Definitely. But before analyzing the 135-page court decision, we need to ground this legal research in human reality. We need to show you exactly what this freeze looked like on the ground.
And our researchers provided a case study that I think perfectly illustrates the mechanics of this freeze.
Yeah, let's talk about Chidera.
Chidera's timeline is meticulously documented in our research. His story is the archetypal example of how an individual's life can be entirely derailed by an unpublicized internal memo.
Okay, so let's walk through his journey meticulously. Chidera arrived in the United States from Lagos, Nigeria, back in 2019.
On an H-1B visa.
Right. And just getting an H-1B is an ordeal in itself, isn't it?
Oh, it is a monumental hurdle. The H-1B is a highly coveted temporary visa for specialty occupations.
So it means he has specialized skills.
Yes, typically requiring at least a bachelor's degree or higher. It also means he found a U.S. employer willing to sponsor him and pay significant filing fees.
And they have to prove they are paying him the prevailing wage, right?
Exactly. But even after all that, the H-1B is subject to an annual cap. It is basically a lottery system.
So even if you qualify, you might not get it.
Right. Historically, the chances of simply being selected in that lottery have hovered around 20 to 30%.
Wow, so Chidera beat incredible odds just to set foot in the United States legally in 2019.
He didn't just walk in. He was heavily vetted and selected.
Okay, so he gets here, he starts working, he pays taxes, he builds a life. Then, by 2024, his employer decides they want to keep him permanently.
They file an I-140 petition, and it gets approved.
How big of a deal is that step?
It is the defining milestone in employment-based immigration. The I-140 is the immigrant petition for alien worker.
What does that actually require?
To get that approved, the employer usually has to go through the PERAM labor certification process with the Department of Labor.
Yeah.
This takes years.
Years? Just for the certification?
Yes. The employer has to run advertisements in local newspapers, post notices, and actively try to recruit U.S. workers for Chidera's exact position.
Oh, so they have to prove no one else can do the job.
Exactly. Only after proving to the Department of Labor that there are absolutely no willing, qualified, and available U.S. workers can they file the I-140 with USCIS.
That sounds exhausting.
Furthermore, they have to prove the company have the financial ability to pay Chidera's wage permanently.
Right. So when USCIS approves an I-140, the government is officially acknowledging, yes, this U.S. business fundamentally needs this specific foreign worker.
On a permanent basis, yes.
So he has cleared the biggest hurdles. He has the approved I-140, he has the committed employer.
And then in early 2025, he takes what should be the final step.
Right, he files his I-485 application. That's the actual adjustment of status, the final form to get the green card.
He pays his fees, he does his biometrics, he is at the finish line.
At this stage, he is just waiting for the procedural sign-off, right?
Exactly. The heavy scrutiny regarding his qualifications and the labor market has already been completed.
But then, in late 2025, the travel ban was expanded, and Nigeria, Chidera's birth country, was added to that list.
And this is where things go completely off the rails for him.
Yeah, USCIS quietly placed an indefinite hold on his case. And when I read this in the research, the mechanics of how this hold worked were genuinely shocking to me.
It is vital to understand those mechanics because that is the crux of the eventual lawsuit.
How did it actually work?
Well, when most people hear the word hold in an administrative context, they picture a caseworker sitting at a desk reviewing a specific file.
Right, like looking for a missing tax document or an inconsistent date.
Exactly, and placing a physical sticky note on it that says, hold for further evidence. That is individualized review.
Which makes sense.
Yes, it is normal, but that is not what happened to Chidera.
What actually happened?
There was no individual review. An officer did not look at his flawless employment history or his spotless criminal record.
So there was no specific flag raised on his file at all?
None. Instead, the agency implemented a sweeping systemic directive. It was basically a digital dragnet.
A digital dragnet?
Yes. The system was essentially programmed to look at one singular data point, the applicant's country of birth.
Oh, wow.
If that data point matched a country on the newly expanded travel ban list, the file was administratively frozen. Period.
Just taken out of the queue.
Taken out of the processing queue and shelved. Chidera was frozen purely because he was born in Nigeria.
Regardless of the fact that he was already living and working legally in the U.S.
Right, and had already been vetted multiple times and already had an approved permanent worker petition.
I was trying to come up with a way to explain how infuriating this specific scenario is.
How would you describe it?
It's like paying for a flight, passing the TSA background checks, boarding the plane, and taking your assigned seat. You're strapped in.
Okay, I follow.
But the plane just sits on the tarmac for a year. It never moves. The captain never makes an announcement.
That sounds like a nightmare.
Right. You're looking out the window, and you see hundreds of other planes taking off and landing all around you.
But you are stuck.
Yeah, because secretly, air traffic control has decided your specific plane isn't allowed to take off. Not because of a mechanical issue, but because of some internal classification that nobody will explain to you.
That is an excellent analogy, and why you are stuck on that tarmac. Your life outside the plane is falling apart.
Let's talk about that domino effect.
We have to look at the collateral damage of this freeze, which our legal team detailed extensively. It wasn't just a matter of Chidera waiting a little longer for a piece of plastic.
What else happened?
Well, by early 2026, because his green card application was frozen in time, his employment authorization document, his EAD, eventually lapsed.
Wait, explain how those are connected. Why does the green card freeze cause his work permit to fail?
When a person files an I-485 to adjust their status to a permanent resident, they are generally allowed to file for a temporary work permit.
The EAD?
Exactly, to keep them legally employed while the government takes its time processing the main application. These EADs usually have to be renewed every year or two.
So if the main I-485 application is completely frozen...
The agency is also freezing the adjudication of the EAD renewals attached to it.
Wow. So because they stopped working on the green card, they stopped working on the temporary bridge that kept him employed.
Yes. So Chidera's EAD expires. Suddenly, his employer is legally prohibited from keeping him on the payroll.
The same employer who spent years and thousands of dollars proving they desperately needed him.
The very same. They are forced to put him on unpaid leave or terminate him to comply with federal labor laws.
So Chidera loses his income.
Furthermore, he had a pending family petition to bring relatives over from Lagos. That was entirely stalled because he couldn't finalize his permanent residency.
So his career, his livelihood, and his family reunification were all effectively paralyzed.
All of it, just paused indefinitely.
I need to pause here and make something explicitly clear for our listeners. Because anytime we start talking about travel bans, things get very heated politically.
They certainly do.
The travel ban itself was a policy initiated during the Trump administration. It is a highly debated political issue, and you will find strong, passionate arguments on both sides of the aisle.
Regarding national security versus immigration access.
Exactly. But the focus of the legal research provided by attorney Chris Ingram and our focus today is absolutely not a political commentary on the underlying travel ban.
That distinction is paramount. The external travel ban restricts entry into the United States from abroad.
It dictates who can get a visa at a foreign embassy and board a flight to America.
Right. What we are analyzing today is an entirely separate legal issue.
We're looking at how the administrative agency, USCIS, applied that policy to domestic applications, right?
Yes. How they secretly applied it internally. We're examining how the government treated people who were already physically present inside the United States.
People who were already integrated into the workforce and who were already paying fees for services.
Exactly. Our analysis is strictly rooted in administrative law, looking purely at agency procedure, not partisan politics.
So we have thousands of individuals like Chidera trapped on this administrative tarmac. They're losing their jobs, their lives are on hold.
And they have no idea why.
Right. So how did a federal court finally step in and pierce this veil of administrative silence? Let's get into segment 2 and break down the June 5th landmark ruling.
This is where we see the judicial branch exercising its fundamental role as a check against executive agency overreach.
The case that blew this wide open is Dorcas International Institute of Rhode Island v. USCIS.
Decided on June 5th, 2026 by Chief Judge John J. McConnell, Jr.
in the U.S. District Court for Rhode Island. And I understand the judge issued a 135-page opinion.
He did.
That seems incredibly long for an administrative ruling.
It is exceptionally long, and that length speaks volumes about the depth of the court's investigation.
Because it means they really dug into the details.
Exactly. A 135-page ruling means the judge didn't just look at the surface-level arguments. The court forced the government to open its filing cabinets.
They looked at years of internal emails and memos.
Emails, data sets, and hidden policy directives. They conducted a microscopic autopsy on how USCIS was operating behind closed doors.
And what Judge McConnell found resulted in him striking down 4 distinct, sweeping internal policies.
He legally vacated them.
We really need to break these 4 policies down. Because reading through the research from our legal team, the sheer scope of what the agency was doing secretly is astonishing.
It really is unprecedented.
Let's look at the first one. The benefits hold policy. How exactly did this work?
The benefits hold policy was the primary engine driving this crisis. It was the directive that officially mandated the pause.
Okay, so it was an actual written rule.
Yes. The policy instructed adjudicators to halt the processing of green cards, EADs, and naturalization applications.
Naturalization being the process of becoming a U.S. citizen.
Right. And it halted them for nationals of the 39 countries affected by the travel bans.
So if your file crossed a desk and your birthplace matched the list, what did the officer do?
The officer was instructed not to touch it. It was a categorical halt. This is the exact mechanism that trapped Chidera.
Wow. Okay, the second policy is the one that really caught me off guard. The Global Asylum Hold Policy.
It's a shocking one.
The name itself implies something much larger than just the travel ban countries.
It does, and it highlights how blunt and clumsy bureaucratic instruments can be. The global asylum hold policy paused the adjudication of affirmative asylum and withholding of removal claims.
But crucially, this applied globally, right?
Yes. Unlike the benefits hold we just discussed, this asylum freeze applied globally. It applied to applicants from every single country on Earth.
Not just the 39 listed in the travel bans.
Not just those 39, every nationality.
Wait, so if I'm from Venezuela or Ukraine or China, countries completely unrelated to the travel ban restrictions, my asylum case was still frozen.
Yes, it was completely paused.
How on earth did the agency justify that?
They essentially argued that parsing out the affected nationalities within the already overwhelmed asylum system was too administratively complex.
Too complex, really.
Yes. They claimed that managing the new security review requirements introduced by the travel bans would strain their resources so severely that they needed to hit the pause button on massive swaths of the entire asylum system worldwide.
That is a massive dragnet.
It is. Instead of using a scalpel to address security concerns from specific regions, they used a sledgehammer and stopped the clock for vulnerable populations globally.
People who were seeking safe harbor in the U.S.
Exactly.
That is wild. Okay, the third policy the judge vacated is called the Comprehensive Re-Review Policy. And reading about this one gave me genuine anxiety.
It is arguably the most aggressive and disruptive of the four policies.
Why is that?
Because it attacks the core legal principle of finality. The Comprehensive Re-Review Policy forced USCIS officers to go backward.
Go backward.
Yes. They were ordered to reopen and re-examine immigration benefits that had already been approved for affected nationals.
Going back how far?
Going all the way back to January of 2021.
So you go through the entire gauntlet, you wait years, you get your approval notice in the mail.
You celebrate.
You buy a house, you establish your career, you build your life under the assumption that your legal status is secure. And then years later, an officer gets a memo telling them to dig up your archived file and look for a reason to undo it, solely because of where you were born.
Yes. It fundamentally undermines the presumption of validity.
What does that presumption mean?
In administrative law, once the government grants a benefit, there is a legal presumption that the decision was correct and valid.
So they can't just take it back for no reason.
Exactly. Unless the government uncovers specific evidence of fraud or criminal misrepresentation, they cannot simply change their minds years later.
But this policy stripped away that protection.
It meant that for these specific nationalities, an approval wasn't actually final. It was conditional, subject to retroactive scrutiny at any moment.
That is terrifying. The final policy struck down is the country-specific factors policy. How did this one alter the adjudication process?
Well, many immigration benefits, including adjustment of status to get a green card, are not automatically granted just because you meet the technical requirements.
There is an element of officer discretion.
Yeah, there is. The adjudicator must weigh the positive factors in your life against any negative factors.
So positive factors like employment history, community ties, family in the U.S.
Right, and negative factors like past visa overstays or minor legal infractions.
So what did the country-specific factors policy do?
It was an internal directive instructing officers to treat an applicant's nationality being from one of the affected countries as a, quote, significant negative discretionary factor.
So the officers ordered to put a heavy weight on the negative side of the scale before they even open the envelope to see who you are.
Exactly. Even if you were a perfectly compliant applicant.
You could have a spotless record, an advanced degree, pay significant taxes.
But the moment the officer saw your birthplace, you were already starting the race 10 yards behind the starting line.
The policy institutionalized a disadvantage based entirely on national origin.
It did. It codified bias into the adjudication process.
When you look at these four policies operating simultaneously, the scale of the impact is staggering.
Truly massive.
And our researchers included some vital context that David Beer, who is an immigration policy analyst at the Cato Institute.
He actually testified before the Senate Judiciary Committee about this entire debacle.
Based on his analysis, USCIS collected over $1 billion in fees. That is, billion with a B.
Yes, from over 2 million applicants.
Over 2 million applicants that they were actively, secretly refusing to process. Beer called it one of the largest immigration frauds in American history.
It is a staggering financial reality.
Okay, let's unpack this. How does a government agency, filled with lawyers and administrators, legally justify collecting $1 billion for a service it has secretly created a policy not to provide?
That was the central question before Judge McConnell. How is this legal?
And what was his answer over those 135 pages?
That it wasn't. They could not legally justify it. And to understand why, we have to talk about the Administrative Procedure Act, or the APA.
Let's do a deep dive on the APA, because I see this term thrown around in the news a lot regarding federal agencies. But I don't think most people understand what it actually is or how it protects them.
The Administrative Procedure Act was passed by Congress in 1946. It is essentially the operating manual for the entire federal bureaucracy.
Okay, so it governs how agencies work.
Yes. You have to remember that Congress writes the broad laws, but they rely on executive agencies to implement the daily mechanics of those laws.
Agencies like the EPA, the FDA, or in this case, USCIS.
Right. The danger is that unelected agency officials wield massive power. The APA was created to prevent those agencies from going rogue.
It requires agencies to be transparent, right?
Yes. If they want to change a major rule, the APA usually requires them to publish the proposed rule and allow the public to comment on it.
So they can't just make up rules in the dark.
Exactly. And most importantly for this case, the APA gives federal courts the authority to review and strike down agency actions that violate specific standards.
What are those standards?
A judge can vacate a policy if it is found to be contrary to law or arbitrary and capricious.
And how did the judge apply those standards to these USCIS freeze policies?
Judge McConnell found that USCIS was acting contrary to law because Congress mandates the collection of those application fees specifically to fund the processing of the applications.
Oh, so the fees are legally tied to doing the actual work.
Yes. The agency does not have the statutory authority to take the money and then intentionally refuse to do the work.
That makes total sense. And what about arbitrary and capricious?
Applying a blanket freeze without any individualized assessment and retroactively re-reviewing approved cases without any evidence of fraud was textbook arbitrary and capricious behavior.
Because there was no logical connection to individual cases.
Right. There was no rational, logical connection between the facts on the ground and the extreme actions the agency took.
And there was a direct quote from the judge's ruling highlighted in our legal research that is just incredibly forceful.
It is a stunning judicial statement.
And again, a quick reminder to our listeners. We are maintaining our strict nonpartisan stance here. We are not expressing our own political opinions.
We are simply quoting the official findings of a federal judge in a 135-page ruling regarding agency conduct.
Exactly. So Judge McConnell wrote that USCIS justified these massive freeze policies with, and I quote, pretextual concerns of national security that mask anti-immigrant sentiments, that it is forbidden from letting influence its decision-making.
In the realm of administrative law, that is an incredibly severe judicial rebuke.
They said my EB1 needed more categories. I can't even dock. What am I gonna do?
I need to find the right lawyer that can navigate me through this crisis. I need my EB1 so my new life can begin. These lawyers are amazing. They are walking me through every questions, making sure I don't miss a thing. Thanks to the law offices of Chris M. Ingram, I'm cleared to land. But my career is gonna take off.
Houston. He got his visa.
Need help with your visa? Book your free consultation now at www.breakthroughusa.com and let us take care of you.
Let's break down the word pretextual. What does that mean in this context?
When a court uses the word pretextual, it means they looked at the evidence and concluded the agency wasn't telling the truth about its motivations.
So the agency claimed they needed these massive freezes to conduct complex national security reviews.
But the judge looked at their internal data and said, no, that is a smokescreen. You use national security as a pretext to enact sweeping halts driven by prohibited sentiments. When a federal agency allows forbidden, arbitrary factors to dictate how it processes legally filed applications, it shatters the bounds of the Administrative Procedure Act.
And that is why Judge McConnell didn't just ask them to modify the policies. He vacated all 4 of them nationwide.
He tore them down completely.
So, hearing all of this, it sounds like an absolute total victory for the applicants. The invisible wall has been torn down. The $1 billion wasn't wasted.
It looks that way on the surface.
But reading through the second half of the research prepared by our legal team, there is a massive red flashing light.
There is.
They make it very clear that navigating the aftermath of a massive court order like this is essentially a legal minefield.
It is a highly volatile environment. A federal court order changes the legal architecture, but it does not instantly change the physical reality on the ground without proactive engagement.
Right. If applicants misunderstand what this ruling actually does, they can make catastrophic, irreversible mistakes with their cases.
Which brings us to segment 3.
Exactly. This is what I consider the most important part of our deep dive today. We are going to spend a significant amount of time right now really unpacking this over the next 20 minutes or so, because our team identified 5 dangerous misconceptions about this ruling.
These are the things people are getting completely wrong based on headlines.
And we need to dissect every single one. Let's start with the big one. Misconception number 1. People believe the travel ban itself has been struck down.
This is the most prevalent and dangerous point of confusion. We must draw a very thick, clear line between 2 entirely different spheres of the U.S. immigration system.
What are those 2 spheres?
Consular processing abroad versus domestic processing inside the United States.
Okay, let's break that down.
The travel bans, which were implemented via specific presidential proclamations in June and December of 2025, govern the entry of foreign nationals who are currently outside the United States.
Those bans operate through the Department of State?
Yeah. Yes. They dictate what happens when a person walks into a U.S. embassy in Lagos or Tehran or anywhere else on the list and asks for a visa to board a plane to America.
And the Rhode Island court decision did what to those proclamations?
Absolutely nothing.
Wait, really? Nothing at all?
The federal judge in Rhode Island did not strike down the presidential proclamations. The external travel bans restricting entry into the United States from abroad are still fully active and legally enforceable today.
So to be crystal clear, if you are sitting in a foreign country right now and that country's on the restricted list, this court ruling does not help you get a visa to come into the U.S.
Correct. What the court struck down was the internal domestic mechanism.
They struck down the policies created by the Department of Homeland Security, specifically USCIS.
Yes, the policies that froze the applications of people who were already legally inside the United States.
So if you were already here on an H-1B or a student visa and you filed your paperwork domestically, you fall under the jurisdiction of USCIS.
And the judge ruled that USCIS cannot use the existence of the external travel ban as an excuse to freeze the domestic processing of people already within U.S. borders.
So they are 2 entirely separate legal jurisdictions. The border versus the interior?
Exactly.
Okay, that is a vital distinction. Let's move to the second major trap. Misconception number 2. Because the judge struck down the freeze, USCIS will automatically process every frozen case.
That assumption breeds a very dangerous complacency.
I imagine people think they can just sit back and wait for the approval notice to arrive in the mail now.
They do, and it's a mistake. Our legal research includes an excellent insight from Anisa Rahim, the legal director of the South Asian American Justice Collaborative.
What did she say about this?
She pointed out that while the legal barrier has been removed for thousands of immigrants lawfully seeking benefits, the practical delay is far from over.
Why is that?
The hard mechanical reality of government bureaucracy is that a court order creates an obligation, but it does not magically create momentum.
Right. It's like, imagine you are driving and you come to an intersection where a police officer has put up a physical barricade and a stop sign.
Okay.
You sit there for an hour. Finally, a judge radios the officer and says, take down the barricade. The officer removes the stop sign.
That's great. The legal roadblock is gone.
But your car isn't going to magically float through the intersection on its own. You still have to manually put the car in gear and press the gas pedal yourself to move forward.
That captures the mechanics perfectly. You have to remember the sheer physical and digital scale of USCIS.
We are talking about a sprawling bureaucracy.
Yes, managing millions of files across massive service centers like the National Benefit Center or local field offices.
So when Judge McConnell says you can no longer freeze these cases, USCIS doesn't have a giant red button they press that suddenly spits out 2 million approvals the next morning.
No, they don't. Think back to the analogy of the locked drawer. The judge ordered the agency to remove the lock.
But your specific physical or digital file is still sitting inside that drawer, buried under thousands of others.
Someone still has to physically open the drawer, pull your file out, assign it to an adjudicator, review the merits, and process the paperwork.
So if you simply sit back and wait for the agency to proactively realize they delayed your case and rush to fix it,
you will be waiting a very, very long time. You have to compel them to move.
which brings up an even scarier thought, leading to misconception number 3. People assume the government has simply accepted this ruling and given up.
If you study the history of high-stakes administrative litigation involving massive federal policies, the government almost never just folds its cards after a loss at the district court level.
They will fight it.
The Department of Justice, representing USCIS, will almost certainly appeal this decision to the First Circuit Court of Appeals.
Let's break down the architecture of that. The First Circuit Court of Appeals, how does that relate to the Rhode Island judge?
Well, the federal court system has a hierarchy. Judge McConnell is a district court judge. That is the trial level. The loser at the trial level has the right to appeal to a higher circuit court. Rhode Island falls under the jurisdiction of the First Circuit.
So the government will go to the appellate judges and argue that Judge McConnell interpreted the Administrative Procedure Act incorrectly.
Yes. But the appeal itself isn't even the most immediate danger.
What is the immediate danger?
The immediate danger is that the government will file a motion for a stay of the district court's ruling.
We really need to explain what a stay is mechanically, because this could change everything overnight.
A stay is a legal pause button. The government's attorneys will go to the First Circuit and argue, Your Honors, if we are forced to comply with this district judge's massive order right now.
If they have to start processing hundreds of thousands of frozen files immediately.
Exactly. They will say it will cause irreparable harm to the agency's resources and operations if we eventually win this appeal a year from now.
Because they can't easily undo those approvals.
Right. So they say, please pause the judge's order. Let us keep the freeze in place temporarily while we argue the merits of the appeal.
And do appellate courts actually grant those stays?
Very frequently, especially when dealing with complex immigration or national security arguments.
Wow.
If the First Circuit grants that stay, the freeze policies that were just struck down could be temporarily resurrected within days.
That invisible wall comes right back up while the litigation drags on for months or years.
Yes. Our legal team phrased this perfectly in the research. In immigration law, a monumental win on Monday can be stayed by Friday.
That is incredibly sobering. A win on Monday, stayed by Friday.
And we must also consider the potential for a circuit split.
What does that mean?
The United States is divided into different geographical federal judicial circuits. The First Circuit covers New England.
Okay.
But what if a similar lawsuit regarding these exact same freeze policies is filed by applicants living in California, which is the Ninth Circuit, or Texas, which is the Fifth Circuit?
Oh, I see.
If the First Circuit upholds the Rhode Island ruling, but the Fifth Circuit rules that the freeze was legal, you have a circuit split.
You essentially have two different versions of federal law operating simultaneously depending on your zip code.
Yes, it is geographical chaos, and it usually continues until the Supreme Court finally steps in to resolve the split.
So assuming this legal battle is neatly finished, just because a district judge issued a ruling is a massive miscalculation. The chess game is still in the early middle phase.
Absolutely.
Okay, let's look at misconception number 4. And I think this is where people could do the most acute, irreversible damage to their own lives.
It's extremely risky.
The misconception is, if your country's on the travel ban list, but the freeze was struck down, you are now safe to travel internationally.
I need to deliver the strongest possible warning here, heavily emphasizing the guidance provided by attorney Chris Ingram's team. Do not travel internationally.
I cannot overstate this either. Do not leave the United States.
Do not do it.
Let's really dig into the mechanics of why, because I completely understand the human impulse. You've been stuck here for years.
It's totally understandable.
You hear on the news, the USCIS freeze against your country has been lifted. The immediate human reaction is, thank God I can finally fly home and see my parents or attend my sister's wedding while my green card finishes processing.
Right, but why is that a fatal mistake?
Because acting on that impulse fundamentally misunderstands who controls the borders versus who controls the interior.
We have to revisit misconception number 1. The external travel ban restricting entry into the United States from abroad is still fully operational.
Right now, if you are physically inside the United States with a pending green card application, you are dealing with USCIS.
They manage domestic status, and thanks to this Rhode Island ruling, they cannot freeze your application.
But the moment you board a flight and leave U.S. airspace, everything changes.
When you try to return, you are no longer dealing with USCIS. You are dealing with CBP Customs and Border Protection at the airport port of entry.
And CBP officers aren't bound by the Rhode Island ruling regarding domestic processing.
Exactly. CBP officers at the airport are enforcing external entry laws. They are bound by the active presidential proclamations.
So, you fly home to visit family. A week later, you arrive at the airport to fly back to the U.S.
Because your passport is from one of the banned countries, you could be denied boarding by the airline before you even reach the gate.
Or worse, you manage to fly back, you land at JFK or LAX, and a CBP officer detains you at border control.
They cancel your documents and put you on the next flight out because you are subject to the active external travel ban.
But wait, don't people with pending green cards usually get advance parole? A travel document that lets them leave and come back? Does that protect them?
That is the insidious trap. Normally, yes, advance parole allows you to travel while your I-485 is pending, but
Yeah.
advance parole does not guarantee re-entry. It only grants you permission to seek parole at the border.
So if the underlying travel ban applies to you, CBP can determine you are inadmissible and refuse to honor the advance parole.
Furthermore, if you leave the United States and are denied re-entry, the government will likely determine that you have legally abandoned your pending adjustment of status application.
Oh, wow. Your I-485 is denied because you are no longer physically present to adjust status.
Your entire journey, the H-1B, the labor certification, the I-140, the years of waiting evaporates at the border checkpoint.
The risk is astronomical.
Unless you have had a rigorous, highly individualized consultation with a qualified immigration attorney who specifically clears you for travel based on a rare documented exception, you must remain inside the United States.
Do not go to the airport. Do not leave. It is not worth losing everything.
Agreed.
Okay, let's move to the final major trap. Misconception number 5. People believe this Rhode Island ruling only applies to the 39 countries listed on the travel bans.
This is where we must revisit the mechanics of that second vacated policy, the global asylum hold.
Right. And I could easily see how a listener might tune out this part of the news.
Because they think it doesn't apply to them.
Yeah, they hear the headlines talking about 39 travel ban countries. They know they are from a country that is definitely not on that list.
Maybe they're seeking asylum from political persecution in South America or Eastern Europe.
They think, okay, this lawsuit has nothing to do with me. Why is that a massive oversight?
Because they are missing the fact that their inexplicable asylum delay might actually be the direct result of this exact federal ruling.
Remember, the agency didn't just freeze the 39 countries.
They implemented the global asylum hold, which paused affirmative asylum applications regardless of the applicant's nationality.
Let's clarify the term affirmative asylum for the listener. How does it differ from other types of asylum?
Affirmative asylum is for individuals who are already physically present in the United States and who proactively apply for protection with USCIS, usually within 1 year of their arrival.
They are not currently in deportation proceedings. They are affirmatively asking for safe harbor.
Right. The alternative is defensive asylum, which happens in immigration court when someone is actively fighting deportation.
Because USCIS handles affirmative asylum, and because they decided the security complexities of the travel ban were too overwhelming, they threw a blanket over the entire affirmative asylum division globally.
So if you are an asylum seeker from a non-banned country, and you have been tearing your hair out wondering why your case hasn't moved in a year and a half.
It might not just be the normal systemic backlog.
Exactly. It may very well have been this specific, now vacated policy holding you back.
Therefore, the relief granted by Judge McConnell is significantly broader than the headlines suggest.
The key takeaway here is that if you are an affirmative asylum seeker anywhere in the U.S. experiencing a prolonged, seemingly illogical delay, the vacating of this global hold is highly relevant to your case.
You are part of this victory, and you need to act on it.
Yes, you do.
Okay, segment 4. We have outlined the invisible wall, we've broken down the judge's ruling, and we have thoroughly walked through the minefield of misconceptions, the stays, the circus splits, the Border Patrol traps.
It's a lot to navigate.
It is. So let's pivot to empowerment. Let's transition from defense to offense. I want you to break down the exact actionable playbook recommended by our researchers.
Happy to do it.
How do applicants actually press the gas pedal and force the agency to move?
Our legal team lays out a highly strategic, proactive playbook, and it all starts with adopting the correct legal posture.
We need to look back at how Chidera's attorney handled the situation, right?
Exactly. The morning after the Rhode Island ruling was published, his legal team didn't just pop champagne and wait.
They immediately engaged the agency. They sent a formal inquiry to USCIS regarding his frozen I-485.
Yes.
What fascinates me about administrative law is the specific tone required. Why a formal inquiry? Why not immediately file a lawsuit demanding action within 24 hours, or write an angry letter demanding an apology?
Because in administrative law, aggressive, demanding theatrics often backfire. You are dealing with human adjudicators and bureaucratic defense mechanisms.
If you bang on the door screaming threats, the bureaucracy tends to entrench itself and push back.
That's just human nature. The strategy is polite, highly documented, on-the-record engagement.
You are essentially slipping a legally binding note under the door.
Right, a note that says, we represent this specific file. We are fully aware of the Dorcas v. USCIS ruling from June 5th.
We know the freeze is vacated. We're officially placing it on the record that we expect processing to resume according to the law.
Exactly.
It's about creating a paper trail.
It forces the agency to acknowledge the new legal reality on your specific case file. More importantly, if USCIS ignores that inquiry and continues to delay your case unreasonably, that polite inquiry becomes Exhibit A in your future lawsuit.
You have proven that you notified them, you gave them a chance to correct the error, and they failed.
It sets the foundation for more aggressive legal action if necessary.
Okay, so let's walk through the specific 5 action steps provided by attorney Chris Ingram's playbook. Step 1 is confirm your case type. Why is this the necessary first step?
Because precision is everything in law. You cannot assume you're protected by this ruling, and you cannot assume you are excluded.
You need a professional assessment of exactly where your application sits within the administrative machinery.
Are you waiting on an I-485 adjustment of status? Is it an I-765 for an employment authorization document?
Is it an N-400 for naturalization or an affirmative asylum claim?
Does your nationality or your specific filing date align with the parameters of the 4 vacated policies?
You need an attorney to definitively diagnose whether your file was caught in this specific freeze or if it is delayed for an entirely different reason.
Right.
Step 2, do not wait passively. We used the traffic light analogy earlier, but what are the actual levers an applicant can pull to press the gas pedal?
There is an escalating ladder of interventions. The first rung might be filing a service request.
What is that?
This is a formal, standardized way of asking the agency for a status update when an application falls outside of published normal processing times.
If a service request is ignored, what's next?
The next rung is the formal legal inquiry citing the recent federal ruling like Chadera's attorney used.
And if the agency simply refuses to act after months of unresponsiveness,
the ultimate tool is a writ of mandamus.
Let's do a quick deep dive on mandamus because it sounds incredibly powerful. What actually is a writ of mandamus?
A writ of mandamus is a specific type of federal lawsuit. You are not asking a judge to grant your green card. A judge can't do that.
You are suing the government in federal court, asking a federal judge to order the administrative agency to do its job and make a decision.
You are arguing that the agency has a non-discretionary duty to adjudicate your file, and their delay has become legally unreasonable.
It is a highly aggressive, highly effective tool, but the bar to win a mandamus is high, isn't it?
Yes, you have to prove the delay is truly egregious. However, given that these freeze policies were just declared arbitrary and capricious by a federal judge, the argument that a continued delay is unreasonable becomes much, much stronger.
But you only get there if you proactively take action.
Precisely.
Step 3 in the playbook is no international travel. We've already hammered this point, but it deserves to be on the checklist.
It remains the most critical rule. Until you have the physical permanent resident card in your hand, or until your attorney has cleared you for travel based on a highly specific analysis of your risk regarding the external travel bans.
Stay within the borders of the United States. Do not test CBP at the airport.
Exactly.
Step 4 is something that I think requires urgent attention for a lot of listeners. The playbook says, treat expired EADs as urgent. Let's extrapolate on this because it's not just about missing a paycheck.
It is about preventing the cascading failure of your entire life in the United States.
When your employment authorization document expires, the immediate effect is that your employer must terminate you to comply with the law.
But the dominoes keep falling. In many states, the expiration date on your driver's license is legally tethered to the expiration date on your EAD.
So your work permit expires, and suddenly your driver's license is invalid. You can't legally drive to the grocery store.
Furthermore, the loss of verifiable income can trigger defaults in mortgage agreements or rental leases.
And it threatens the underlying green card application itself, right?
That is the ultimate danger. If your EAD expires, and out of desperation to feed your family, you continue to work without authorization, you are violating the terms of your status.
Unauthorized employment can, in many circumstances, render you completely ineligible to adjust your status.
The agency can deny the I-485 because you worked illegally. Therefore, an expired EAD caught in this freeze is not a background administrative annoyance.
It is a four-alarm fire.
If your work authorization has lapsed or is about to lapse, you must prioritize legal intervention to force the renewal of that specific document immediately, citing the Dorcas ruling to unfreeze it.
The final step in the playbook.
Right.
Step 5. Monitor litigation. Keep your eyes on the First Circuit and keep checking BreakthroughUSA.com for updates from our researchers regarding Dorcas v. USCIS.
Because, as we detailed extensively, the legal landscape is fluid. A stay could be granted next week.
An appeal could alter the parameters of the injunction.
Proactive case management requires constant situational awareness. You and your legal counsel must be ready to adapt to whatever the appellate courts decide.
So after dissecting 135 pages of legal rulings, internal memos, and complex appellate strategy, what does this all mean for the listener?
We need to synthesize this entire hour and bring it back down to the human element.
Think about Chidera. He did everything right. He played strictly by the rules, he paid the exorbitant fees, he contributed his highly specialized skills to the U.S. economy.
And for over a year, his entire life was completely paused.
It wasn't paused because of his character. It wasn't paused because he made a mistake on a form.
It was paused entirely because of the geographic coordinates of where he happened to be born.
It is a profound and unsettling realization.
It really is. And as we conclude this deep dive, I want to leave our listeners with a broader thought to mull over, something that extends far beyond just this specific travel ban or this specific court ruling.
What's the takeaway?
I want you to consider the sheer, terrifying fragility of the administrative systems that govern our modern lives. We like to think that laws are rigid, objective structures.
But this situation reveals how profoundly an individual's future, their career, the unity of their family, their very ability to legally exist within a country, can be dictated by quiet, unpublicized internal agency memos that nobody voted on.
It highlights exactly why constant vigilance is required. It shows why the Administrative Procedure Act and the checks and balances provided by an independent federal judiciary are the only real defenses we have against institutional overreach.
The massive bureaucratic system is not automatically fair.
In fact, when left to its own devices, a bureaucracy will almost always lean toward its own administrative convenience, even if it crushes individuals in the process.
True fairness and true due process do not happen automatically in this system. Fairness usually has to be legally forced.
Very well said.
Thank you so much for being with us today. We hope you gained a lot from this discussion. Please leave us a comment if you can. Additionally, you can support our channel by sharing it with your friends and family, helping us build this community together. Also, follow us on Spotify, YouTube, LinkedIn, Facebook, X, and Instagram, where we're growing rapidly thanks to our social media team. We would also like to thank attorney Chris Ingram and his dedicated team once again for researching and preparing this material for our presentation. See you next time on Let's Talk U.S. Immigration. Bye for now.